Sí, buenos días, amigos de la Universidad Nacional Autónoma de México. Estamos en esta conferencia internacional que está siendo organizada a través del Centro de Investigaciones sobre América del Norte, CISAN, en coordinación con la Laureation University y el Consorcio Binacional Universidad de Arizona, UNAM, sobre migración, derechos humanos y seguridad humana en el marco del seminario trinacional Actores Emergentes en Seguridad Humana. Les agradecemos mucho su compañía. Mi nombre es Luis Coronado y el día de hoy, como les decía, estamos presentando la conferencia que será impartida por el doctor Henry Pollard de la Laurentian University en Canadá y cuyo título se dice The Supreme Court of Canada and Medical Assistance in Dying. Y para este efecto tenemos también aquí, estamos muy honrados por la presencia de representantes de la Universidad Laurentian, quienes son tanto el ponente, doctor Henry Pollard, como el doctor Jorge Virches. Y también tenemos el gusto de tener al doctor Roberto Cepeda, coordinador del área de estudios de la integración en el Centro de Investigaciones sobre América del Norte, doctor. Y también quisiera presentarlos. Nos iba a acompañar o no, está por acompañarnos el doctor Juan Carlos Barrón, quien es el secretario académico del CISAN en la UNAM. Asimismo, queremos externar nuestro agradecimiento, como siempre, a la doctora Graciela Martínez Salce, directora del Centro de Investigaciones sobre América del Norte, por hospedarnos en este espacio virtual de la UNAM en la Ciudad de México. Muchísimas gracias. Paso en primer término a dar una semblanza de nuestros presentadores el día de hoy, de nuestros conferencistas y nuestros acompañantes distinguidos. En primer lugar, presento al doctor Henry R. Pollard, que es profesor titular e investigador y profesor emérito de la Universidad Laurentian en Canadá. Es director y fundador del Centro Internacional para la Investigación Interdisciplinaria en Derecho. También que fue creado en 1993 este centro que promueve y apoya la investigación en derechos humanos, democracia y Estado de Derecho. Estudió Derecho y presentó su examen ante el Colegio de Abogados en 1988 en la provincia de Ontario. El doctor Pollard ha escrito 35 artículos científicos dictaminados y publicados en revistas académicas internacionales, así como 10 libros y capítulos de libro sobre temas de democracia, cultura, elecciones federales y provinciales en Canadá, Estado de Derecho y libertad de religión. Además, tuvo un proyecto de casi $1 millón canadienses sobre pobreza, migración y población sin casa en la región subártica de Ontario, Canadá. Ha sido profesor invitado en muchas universidades de 4 continentes. El doctor Pollard es considerado una eminencia en cuanto a estudios de las personas sin hogar, pobreza, sobre minorías culturales y derechos fundamentales, así como la libertad religiosa. Su obra académica es ampliamente reconocida y citada en países de África del Norte. Muy bienvenido, doctor Pollard. Y también doy la bienvenida, doctor Pollard. Doy la bienvenida también al doctor Jorge Virches, quien es profesor emérito de la Universidad Laurentian en Ontario, Canadá también, y ha sido profesor en el Departamento de Geografía de esta universidad desde hace 30 años. El doctor es doctor en Geografía Económica por la Universidad de Laval en Quebec, Canadá. Asimismo es profesor asociado en el Centro de Estudios Canadienses de la Universidad de Guangdong en China. Ha publicado varios libros en inglés, francés y español, y además ha publicado en revistas académicas más de 30 artículos de investigación. Sus intereses se centran en diversos temas como las relaciones indígenas y la geografía de Canadá y de Norteamérica. Es miembro fundador del programa de maestría de relaciones indígenas de la Laurentian University y es miembro también fundador del Comité de Intendencia de Mejoramiento Ambiental del Río Juncture Creek y ha investigado y publicado sobre impactos del cambio climático y del Ártico canadiense. El doctor Birches ha venido trabajando sobre resiliencia y subjetividad en comunidades indígenas canadienses en la región del subártico en Canadá, así como en la problemática de la pobreza y la seguridad alimentaria del norte de la provincia de Ontario. Y para nosotros, doctor, es un honor también tenerlo presente el día de hoy. Bienvenido.
Gracias.
Asimismo, contamos con el doctor Roberto Cepeda, quien es investigador del Centro de Investigaciones sobre América del Norte y al cual extendemos una enorme felicitación por su reciente nombramiento como coordinador del área de estudios de integración del Centro de Estudios sobre América del Norte. Roberto, bienvenido. Y bueno, pues como les decía, el doctor Juan Carlos Barrón envía un saludo, está por integrarse a esta mesa, pero sin más ni más, quiero dar la bienvenida al doctor Henry Palar y también a nombre de la Universidad de Arizona agradecemos este espacio. Dr. Henry Palar, the voice is yours. Thank you so much for being here.
Well, thank you very much for the introduction. My colleague, Dr. Michel Giraud, and I are very pleased to present today. And I want to underline the enormous work, the principal work on this presentation has been done by my colleague, Michel Giraud. And thank you for the welcome. And it's really a pleasure to be presenting in Mexico City on such a cold winter's day. What I would like to talk to you today about is we would like to say is about the Supreme Court of Canada and a particular decision about the medical assistance to dying. And what occurred in this is you have to understand the relationship of the courts system to the various governments. Very briefly, Canada is a constitutional monarchy and democratic government with the executive headed by the prime minister, a parliament, and a judiciary, an independent judiciary. And then we have federal and provincial jurisdictions that are both autonomous in their fields. One is not subservient to the other. Oops, I took the wrong one. Okay. And so the Charter of Rights that we're talking about is a document that came into effect in 1982. 1982, I'm sorry, the Charter of Rights and Freedoms, and it has changed the relationship between the courts and the parliament and the executive, where the courts now have the power to declare legislation unconstitutional because violating rights and freedoms guaranteed in the Charter of Rights and Freedoms. And one of the and what we're going to be looking at today is an article of the Criminal Code of Canada that prohibits assistance to people to commit suicide. Suicide itself is not criminalized in the Criminal Code of Canada. That was decriminalized some time ago, but one is not allowed to bring assistance to people who want to commit suicide. And this decision comes from the Supreme Court of Canada. It's an autonomous institution here in Canada. The judges are named, once they are named to the Supreme Court of Canada, the 9 judges are there for life. Life for a judge ends at age 75 in Canada when they are forced to take their retirement. And the close nexus between the Supreme Court and the federal power and the Parliament is seen because the Supreme Court building is simply down the street from Parliament. One walks down 100 yards and one finds from Parliament, one finds the Supreme Court of Canada. So the question that we're going to look at today is the question of the 2 cases decided by the Supreme Court of Canada of roughly 22 years apart. One is Rodriguez against British Columbia, the province of British Columbia. The other one is Carter in Canada. And essentially, there is nothing distinguishing these two cases on the facts, except that in the first case, the Supreme Court of Canada said that the prohibition of assistance to people who wanted to commit suicide was a constitutional prohibition. In Carter, the court came to the exact opposite conclusion, and it did so this time unanimously. And the question that the court had to decide in the second case was the criminal code prohibition forbidding people to assist others to commit suicide, whether it was compatible or incompatible with Section 7 of the rights and freedoms guaranteed by Section 7 of the Charter, the right to life, liberty, and security of the person, and the right not to be deprived except in accordance with the principles of fundamental justice. Then there's a question of Section 1 we'll come to afterwards, but essentially that is the important question that the court had to decide. And in Rodriguez, I've already said the court had decided that there was no charter violation. It found it to be constitutional, and it was also justified under Section 1 of the Charter. Now, Section 1 of the Charter is the Derogation Clause, which allows Parliament to adopt laws that infringe rights guaranteed in the Charter, but then those rights must be reasonable. There must be a limit. There can't be a prohibition. There must only be a limit, and the measure must be reasonably demonstrable in a free and democratic society. And in a 5-4 decision in Rodriguez, the court found that the prohibition was constitutional. What happens 22 years later is the very same case comes to the Supreme Court of Canada, and it's important that we look at what happens at first instance. Justice Lynn Smith at the Supreme Court of British Columbia hears the case and decides, first of all, that she is not bound by the previous decision of the Supreme Court of Canada. Now, that upset everybody who knows anything a little bit about the common law and the theory of precedent, where lower court judges are bound by decisions of the higher court judges. So Justice Lynn Smith sits at the Supreme Court of British Columbia, and above her is the Court of Appeal of British Columbia, and above the Court of Appeal of British Columbia is the Supreme Court of Canada. Consequently, one would think that, given the facts that what we are dealing with are the same in all cases, is that she would be bound by that decision, and she found that she is not. And we will get into those reasons a little bit later on. But and what is interesting to note here is that how the facts that Justice Smith will find in order to distinguish her decision in Carter from the Supreme Court's decision in Rodriguez, the Supreme Court of Canada will find very persuasive and will accept them and will use them to uphold the decision of Justice Lynn Smith. And so all the hard work had been done at first instance by Justice Lynn Smith, and the Supreme Court of Canada simply had to go in and say, yes, you've been correct, you've decided this correctly, you've decided that correctly, your reasoning here is sound, and uphold her decision. What is interesting, what happens is, between the first instance decision and Supreme Court of Canada decision, is the British Columbia Court of Appeal steps in, and the British Columbia Court of Appeal has no hesitation in overturning Justice Smith's decision and telling her that she has to follow precedent, the previous decision of Supreme Court of Canada in Rodriguez. One can appreciate that the Court of Appeal is going to take a pretty dim view of judges not following the decision of a higher court, because it means that those judges in the lower courts then will not follow their decisions, the decisions themselves of the Court of Appeal. Now, it's not a mystery that the Supreme Court of Canada comes to that conclusion, because it tells us what is it in its very first paragraph. And I will read you it's a short paragraph, 6 lines long. And the Supreme Court of Canada starts off by saying, in Canada, it is a crime to assist a person to end his or her life. As a result, seriously and irreparably ill persons cannot seek the assistance of a physician to die and may be condemned to a life of acute and intolerable suffering. Faced with such a prospect, they have 2 options: either to end their lives prematurely, often by violent or dangerous means, or to suffer until they die of natural causes. And then the telling phrase, the Supreme Court tells us, the choice is cruel. Now, we all know that judges are not cruel. We all know that the Supreme Court of Canada is not cruel. And so consequently, the Supreme Court of Canada has told us at the end of this first paragraph the decision that it will come to. And it will, because it's not cruel, it will allow Ms. Carter the right to medical assistance in committing suicide. The unspoken question here is that if the Supreme Court of Canada is not cruel in Carter, we could ask ourselves, have the judges in Rodriguez been cruel in denying Ms. Rodriguez the right to aid in ending her life? So this was now there's something really important about this decision. There are many, many important things about this decision, about the relationship of judges to the political power. One of the things is that this is an unsigned decision. It's a unanimous decision. Quite often you get a unanimous decision and one of the judges will write the decision for the other judges, sign their name to it, and all the other judges say, we join, we join, we join. In this case, we don't get that. We simply get the decision from the court. So no individual judge is speaking. And that is really important. It's the court that puts itself out. Now, first of all, we have to know a little bit of political history. Is at this point, the Supreme Court of Canada was engaged in some political warfare with the what I would call political warfare with the federal government of Canada. And the federal government of Canada was the Prime Minister of Canada, Stephen Harper, was openly criticizing the Chief Justice, Beverly McLaughlin. Okay, never seen. You know, the Chief Justice is seen as being apolitical, and all of a sudden to have a political partisan attack on the Chief Justice, the head of the third branch of government, by the head of the executive branch of government, was really unseemly. And so we have to be aware. And so what the court is doing is by not signing the judgment, presenting as judgment of the court, is presenting a united front and saying it's not an individual judge that's giving this decision. This is really the court. The second thing is we have to keep in mind the court is overturning Rodriguez. And it's incredibly important. And it's very, very important, given that it's overturning Rodriguez. And Rodriguez is not an old precedent. Rodriguez is only 22 years old. And so that the court now all of a sudden decides that it's going to overturn a precedent that's only 22 years old. It's just reached the age of majority. That it has to do so in a very solid manner, and having the judges come behind this as a judgment of the court, simply stating the law, is one of the tools that it used. Also, it will rely very heavily, as I've already stated before, on the judgment of Justice Smith in first instance and the findings of fact that she has made. And one of the tools that we use in the common law is when we don't want to follow a previous judgment, we distinguish it on the facts, because the judgment of the court only applies to the facts of the case itself. And so in order to have the rule in that precedent case not apply to new facts, what we do is we distinguish the facts. And Justice Smith has engaged in this wonderful exercise of distinguishing the facts between the case before her and the facts as they existed in the case of Rodriguez. And the court recognizes, and the Supreme Court of Canada legitimizes the démarche undertaken by Justice Smith at first instance, that she has properly distinguished the facts. And she says, and the court said there are two instances where lower court may review the judgments of higher courts, i.e., not be bound by them when new legal issues arise. Yes, we all know that. And also when there are new facts. And we all know that. And so what Justice Smith has done is managed to situate herself in that context. And also the Supreme Court of Canada has validated that context for a lower court judge to overturn, or to not overturn, but to come to a decision that is fundamentally different from the one previously given by the Supreme Court of Canada. So what are some of these changes that have occurred? Well, there's the general acceptance or the moral distinction between passive and active euthanasia. That one has largely disappeared. The existence of a significant consensus in Western countries that the general prohibition on euthanasia is necessary in order to protect the vulnerable people, and we're going to have a slippery slope argument. That has largely disappeared in the meantime, because the Netherlands, Belgium, Luxembourg, Switzerland, Oregon, Washington, Montana, Colombia have all taken the steps towards authorizing medically assisted suicide, and we have not seen the cemeteries filling up with the bodies of dead vulnerable people who have been killed off against their will. And so these changes in facts which justify, which Justice Smith uses to justify distinguishing the facts in Rodriguez, allow her to ground her decision on a different set of facts, and for the Supreme Court of Canada to build on the findings of fact at trial, and to uphold those findings of fact. And it's really important that we understand that the Supreme Court of Canada has consistently held that findings of fact are made by justices at first instance. Courts of appeal and the Supreme Court of Canada should not overturn findings of fact, because they are secondhand in the process. And so they must respect the role of the court at first instance, the proper role of the courts of appeal and the Supreme Court of Canada is to ensure that the law is followed. And only if there's no, if the decision on the facts of the court at first instance is patently unreasonable, there's no reasonable grounds for it, well, then should they intervene. But simply because you disagree with a finding, if it's reasonable, as a court of appeal or as a Supreme Court of Canada, you let that finding stand, even if you disagree with it, as long as it's reasonable. So the question then becomes, how do we get around to the question of finding out whether Section 7 of the Charter, protecting the right to life, liberty, and fundamental justice, how does that affect the how does that affect 241, the prohibition in the criminal code. There are three rights that stand to be potentially violated. One is the right to life. So the prohibition deprives people of the right to life by forcing them to take their own lives earlier than they would like. I am forced to commit suicide earlier because I can do it now rather than doing it later, where I might be incapacitated later on in life. And the court said, the Supreme Court of Canada said, the right to life does not entail an obligation to live. Otherwise, a person could not consent to withdrawal of treatment. And that is keeping them artificially alive. So what we see is that the Supreme Court of Canada adopts a narrow definition of life than the one that was adopted in Rodriguez. And like the trial judge, the court held that the right to life comes into play only if a threat to life from state action, if the threat to life results from state action or legislation. Secondly, we have the liberty, and liberty protects the right to make fundamental personal choices without interference from the state. And then the third right that is under attack through this prohibition is the security of the person. And this puts forward a notion of personal autonomy that includes control over the integrity of one's person without any intervention of the state. So how are these infringements to the right to life and liberty and security of the person inconsistent with the principles of fundamental justice? So the court has found that there's been a violation of Section 7, and we got to look at now to Section 1 to find out whether this violation is justified by Section 1, the Limitation Clause, which allows Parliament to infringe rights, to limit rights guaranteed by the Charter, as long as they meet the conditions set out in Section 1. So as the court says, the prohibition must not be arbitrary, overbroad, or wholly disproportionate to its purpose. So you have to identify the purpose of the prohibition, and the purpose of the prohibition is the same as the purpose that the court found in Rodriguez. That is, we have this prohibition on assistance to suicide is to prevent vulnerable people from being induced to commit suicide in a moment of weakness. So this principle doesn't pose a problem. It minimizes the risk of vulnerable people. However, the court finds that the principle is overbroad and that the protection is unrelated to the harm that Parliament had in mind. The law applies to people who do not fall within the category of vulnerable persons. The law is meant to protect vulnerable persons, that's its purpose, but it also has an effect on other people who are not vulnerable. And then there's a question of disproportionality, and the court will not answer that question. So we come to the questions of how to determine whether there's been this violation of Section 1. And two basic tests must be met. The first is the objective sought. It must be sufficiently important to justify the limitation of a constitutionally protected right or freedom. So the objective, we have to balance the objective sought with the limitation to the constitutionally protected right or freedom. And that objective must be relate to a pressing and substantial concern in a free and democratic society. And secondly, the means chosen must be reasonably and demonstrably justified. That means the application of some sort of proportionality test between the means, the objective, and secondly, the means themselves must interfere as little as possible with the right to freedom in question. So the objective doesn't really pose a problem in this case, protecting vulnerable persons, as I've set out before. The question is whether the means chosen to protect vulnerable people, the total prohibition of medical assistance in dying, meets a proportionality test. Now, the rational connection requirement doesn't pose a difficulty for the court. Where an activity poses some risk, prohibiting it is a rational means of reducing that risk. The court asks itself whether the means chosen by Parliament is the least intrusive on the three rights protected by Section 7. Now, the government's argument was principally based on the slippery slope argument that vulnerable people would come under pressure to end their lives prematurely. And people who are very ill or very vulnerable to the pressure of those around them. And so they would choose to put an end to their lives in an untimely fashion. Now, Justice Smith, at first instance, remember I spoke to you about Justice Smith, had spent a lot of time considering this. And she came to the conclusion, looking at other countries that have legalized and regulated medical assistance in dying, that this was not the case. The government could not support its argument by looking at what happened in other countries. In absolute prohibition, the Supreme Court then said, would only be justified if evidence suggested that physicians were unable to assess the quality of the consent of the vulnerable person, or they were misrepresenting or evading the rule of informed consent. And we didn't have any examples of that. So the judge at first instance, the Supreme Court recognized, found that recognizing a right to medical assistance in dying could be accompanied by carefully crafted safeguards. And these safeguards would ensure the safety of vulnerable persons from abuse and error. In other words, the provision was drafted too broadly. The fear of the government was unfounded because the right to medical assistance in dying in other countries did not lead to a permissive, to an uncontrolled regime. Because if you put in proper safeguards, if careful attention was paid to those safeguards, then you could protect vulnerable people. And the Supreme Court of Canada spent a lot of time relying on the trial judge's findings. And the trial judge, Justice Smith, was confident that qualified physicians had the necessary capacity and intellectual skills to identify real and genuine consent, and a consent that was free of coercion or undue influence. And then the Supreme Court again comes back to the judge at first instance and says, the judges first have examined the situation on the ground And the judge at first sentence, where medically assisted dying has been recognized, where we accept medical assistance in dying, and the judge's first instance has found no examples, no evidence that these vulnerable individuals are more likely than others to be medically assisted to die. So there's no evidence that we have a higher death rate, if you will, from people who are vulnerable than people who are not vulnerable. So I will not get into the question of Bedford. Another question that we could look at, which leads the justice to the Supreme Court of Canada to not follow Rodriguez, because I'm conscious of the time that is flowing on. But I will close by looking at what the court did and how Parliament reacted, and how there's still several more moves that are being played out in this process. So the Supreme Court of Canada found that the impairment of the Section 7 Charter rights was not saved by Section 1 because the means taken were too broad. Consequently, it came to the conclusion that the legislative impairment by the criminal code violated a person's rights and was unconstitutional. The court then suspended its declaration of unconstitutionality for 1 year to give Parliament the time to adopt the proper measure to repair that. And so there would not be this huge legislative vacuum. Now, the Parliament adopted a bill, and the legislators' response was responded to some of the concerns of the Supreme Court of Canada, but it added a couple of elements. One of them was minimum age of 18 to get medical assistance in dying. And secondly, that only those whose death had become reasonably foreseeable, another one of those phrases in the common law that appears everywhere, and so we spend a lot of time on it, what is reasonably foreseeable. Only those people whose death is reasonably foreseeable could avail themselves of medical assistance in dying. And this immediately caused an uproar in the civil liberties milieus, and also for Mrs. Carter, because her death was not reasonably foreseeable. And so what the government has done is shut down one of the ways in which it thought that people who were suffering immeasurable pain, but whose death was not reasonably foreseeable, would not be available to, could not avail themselves of this. And so the debate is ongoing. There's still cases before the courts. A report, the government commissioned a report from the Royal Society of Canada on this issue, and it's an ongoing debate. And given the reluctance of Parliament to get too involved in this, I suspect that this is going to be a matter that's going to end up on the Supreme Court of Canada again, and will be interesting to see whether or not it will defer to Parliament in this case, or whether it will take a harder stand on the right to medical assistance in dying. Could say many more things, but we will turn it over to the questions now. Thank you very much for your attention. Gracias.
Muchísimas gracias por su conferencia, doctor Pallard. Es una conferencia muy, importante en este tema que pues es conectado con los derechos humanos, los derechos fundamentales de las personas, y es muy interesante saber el caso de Canadá en este sentido. Ahora quisiera dar la palabra al doctor Jorge Vilches, a quien ya he presentado con su trayectoria, pero además ahora como comentarista especializado en este tema también que nos ha dado en su conferencia el doctor Pallard. Jorge, si nos haces favor de dar tus comentarios. Muchísimas gracias. Adelante.
Sí, gracias. Bueno, antes que nada, muchas gracias por permitirme dirigirme a ustedes y por haberme recibido aquí en la universidad, en CISAN, que ya es como mi segunda casa. Eh, este tema es muy, muy importante. Yo precisamente, yo tengo un amigo en Quebec que sufría de cáncer y él pidió la asistencia médica para morir y le fue otorgada. O sea, un día me habló por teléfono y me dijo, pues ya tal día ya no voy a estar con ustedes. Eso fue un choque para mí, que realmente yo no estaba muy enterado de esta situación. Pero le dije, ¿pero por qué? ¿Por qué estás haciendo eso? Me decía, Jorge, el cáncer que tengo me está haciendo sufrir. Todos los días estoy sufriendo muchísimo. Entonces, ya no puedo y pues he solicitado lo que llaman el Medical Assistance in Dying. Eh, eh, bueno, lo que nos comentó Henri, bueno, primero nos habló sobre, en Canadá tenemos lo que se llama la Carta Canadiense de Derechos y Libertades, que nos protege, que protege a los canadienses. Después nos comentó de este caso que hubo de una persona, Sue Rodríguez, que en 1993 ella pidió ser inducida a la muerte porque estaba sufriendo una enfermedad muy dura y bueno, pues ahí hubo algunos senadores y algunos diputados que estuvieron apoyándola, que trabajaron muy fuerte para que se aceptara la decisión de esta persona, que sabía que no es una persona vulnerable, sino es una persona que realmente estaba solicitando que ya no aguantaba el sufrimiento, ¿no? Entonces se lo otorgó. Pero después viene el caso de Lee Carter, un poquito más tarde, 22 años más tarde, que ella también quería y quería morir con dignidad, ¿no? Estaba perdiendo sus facultades. Entonces, Henry estuvo hablando de cómo el código criminal y cómo dijéramos, la Suprema Corte de Justicia, cómo se ha implicado en las decisiones, ¿no? de estos casos. Él hablaba de la sección 7 de la Carta, que habla de 3 derechos fundamentales, que son el derecho a la vida, el derecho a la libertad y el derecho de la seguridad, y estar seguro de que no se está abusando, ¿no? ¿Qué tal si hay alguna persona que tenga alguna deficiencia y que no pueda él decidir y estamos decidiendo por él de una forma injustificada? Entonces, para eso está la Suprema Corte, para evitar que haya algún tipo de abusos, ¿no? Después estuvo hablando, bueno, está la sección 241, en el cual dice que, bueno, la asistencia médica para morir, pues hay que estar seguros de que se cumpla la libertad y la seguridad del individuo, ¿no? Que sea realmente él que decida, o que haya dado la autorización a sus familiares. Por ejemplo, alguien que tiene Alzheimer y dice, miren, ya cuando ya esté perdido, pues yo les autorizo a que pues me ayuden a tener una muerte asistida médicamente, ¿no? Después, pues estuvo hablando el caso de qué pasó, ¿no? Las discusiones que se tuvieron entre la Suprema Corte de Justicia y en el 2015 más o menos con el primer ministro Stephen Harper, que no tenían muy buena relación. Entonces normalmente la Suprema Corte no es partisana, o sea, no va a tomar partido por algún grupo político, pero en el caso con Stephen Harper hay una tensión. Después nos habló de cómo el caso de la sí, y llegó a la conclusión de qué es lo que la Suprema Corte ha decidido. Recordemos que en Canadá tenemos un sistema en el cual, bueno, es una monarquía constitucional. Tenemos el poder ejecutivo, el poder legislativo y el poder judicial. Después tenemos algo muy importante, que es la Suprema Corte el sistema judicial de Canadá. Tenemos el Tribunal Supremo de Canadá, que se divide en la Corte Provincial de Apelaciones, pero recordemos que Canadá tiene 10 provincias que funcionan bastante independiente. Ellos tienen su corte provincial, pero también tenemos la Corte Federal. Y también tenemos los tribunales administrativos provinciales y tribunales administrativos federales. Y creo que eso es lo que, en resumen, lo que nos habló Henry. Henry, I just made a comment of your in Spanish, okay? Gracias.
Gracias.
Gracias. Thank you, Dr. Birches, and thank you, Dr. Henry Ballard. Muchísimas gracias, doctor Jorge Birches. Y creo que sí es un tema fundamental que pocas veces nos ponemos a reflexionar, y pues en la medida en la que los seres humanos llegan a una necesidad de una muerte asistida, pues creo que es algo que sin duda los sistemas jurídicos pues es necesario que avancen hasta ese punto, ¿no? Había un término antes que los abuelos utilizaban, el término bien morir. Hay personas que necesitan ayuda precisamente para bien morir, y pues bueno, es un tema que seguramente dará para muchísimo en este seminario. Quisiera ahora pasar la voz al doctor Roberto Cepeda, que probablemente tenga algunos comentarios y también nos ayude pues a darle paso a las preguntas de la audiencia para nuestro conferencista y para nuestros especialistas el día de hoy. Doctor Cepeda.
Muchas gracias, Luis. También un agradecimiento al doctor Henry Ballard por esta interesante conferencia. Many thanks, Henry, for your excellent presentation. I think this is a very interesting topic in Mexico, because we have different legislation in this regard. And it is also very important to talk about these issues related to the freedom, to the liberties of people. And now I was thinking, when I was listening to your presentation, that Canada is quite different from Mexico in this regard. Voy a hablar ahora en español. Yo creo que ese tipo de temas que conciernen precisamente a la Carta Canadiense de Derechos y Libertades, donde en la particularidad del sistema judicial de Canadá, como ya bien lo explicaba de manera muy clara el doctor Jorge Birches, del Tribunal Supremo de Canadá, Yo creo que estos temas es muy importante que se analicen estos casos particulares donde la gente pues tiene derecho pues a morir, a morir con dignidad, ¿sí? Y en este sentido, yo creo que Canadá pues va más adelante, ¿no? Va más adelante en este aspecto como en otros, de tal manera que se habla de que Canadá es un país posmoderno, porque siempre va un poco adelante, ¿no? Y si lo vemos en otros casos, en otros ejemplos que aquí en México se discuten como por ser muy polémicos, en Canadá ya se ha aprobado legislación al respecto, ya se han tomado decisiones y se ha pues avanzado. Únicamente pues mencionar la validez de todos estos temas y de todos estos casos que desde un punto de vista legal pues van creando, ¿no? Van creando un análisis muy importante, pero también una historia que desde el punto, no solo desde el punto legal, iba a decir que estos casos ya se hacen vinculantes, ¿no? Con estas conclusiones de la Corte, con las respuestas que se dan en el Parlamento y se va creando una experiencia, ¿no? En este tipo de casos que en el futuro pues van a decidir, ¿no? Cómo se tome el respecto, ¿no? No sé, tenemos también aquí con nosotros al doctor Michel Jurox. Él también, pues es junto con el doctor Henry Pallard, quienes nos ayudaron a presentar este caso. Él es profesor titular e investigador en el Departamento de Derecho y Justicia también de la Universidad Laurentian. No sé, Jorge, si nos puedes ayudar a pedirle al doctor Michel que nos dé su opinión.
Sí, Michel, we would like to ask you if you can comment a little bit about the presentation of Henri. Roberto was introducing you that, and we would like to hear your opinion.
Thank you, Ori. I think that my comment would, Henri has covered the essential aspects of the decision of Rodriguez and Carter. I would like maybe to expand a bit on the role of the Supreme Court of Canada since the adoption of the Charter of Rights in 1992. And in particular, I would like to speak to its relationship. Ori, you have talked about it. I understand a bit of Spanish. I didn't quite understand everything, but I would like to expand on the subject of the relationship between the executive, the legislative, and the judicial power since the Charter of Rights was adopted in 1982. Now, what's interesting is that when we have Gallup polls on the perception that the public has on judges and politicians, and we compared that situation. The public was asked, there were 10 different professions, and they were asked to put in order which profession they respect the most, which would be number one, and which profession they respect the least, and it would be number 10. And it's interesting because the judges finished second after the medical doctors. That was before the pandemic, obviously. Then I don't know if it would still be the same. But the judges finished second, so they're very well respected in Canada. And the politicians were number 9, right before the used car salesman. So it says a lot about the perception, the fact that the judges are very well respected in Canada, and the politicians have a problem with respectability. Now, the judges are jealous and of that legitimacy that they have. They want to keep it, and they are, the perception and the official ideology state that the judges are supposed to be totally impartial and that the judges are not supposed to care about politics. But what we see is that the judges more and more are quite, they don't want to lose that respect that they have towards the public. And what's interesting is that most fundamental social issues, other than economic issues, are more and more decided by the Supreme Court of Canada. The issues of abortion, we've seen the issues today, the issues of euthanasia, but also the issues of abortion, capital punishment, whether certain drugs should be legal, the issue of same-sex marriage. All those issues have been, the Supreme Court of Canada has been involved in solving those issues. So traditionally, you have this division between executive, legislative, and judicial power. The legislative makes the law, the executive applies the law, and the judicial interprets the law. But since the charter, more and more, the judges act as legislators. And initially, there was no problem because that credibility was very high. But more and more, the Supreme Court takes a position on issues that divide the population. They are becoming more and more aware of the symbolic and political dimension of their decision. And it changes the power struggle between each level of executive, legislative, and judicial. So there has been accusation more and more. There are new concepts that emerges in the world of human sciences, such as a government of the judges, magistrocracy, that makes us realize that, and more intellectual are taking position against the fact that the Supreme Court specifically, but the judges in general, are more and more infringing upon the traditional prerogative of the legislative. So it would explain why in Rodriguez, in the first instance, the Supreme Court hesitated to go all the way to declare a right to die in Canada. Like Henri said, the case was decided 5 judges against 4. There was one judge would have changed his mind, the decision would have gone the other way. But by the time that the court had to make the decision in Carter, Henri was explained clearly that what happened is that now the Canadians were ready for such a decision because different jurisdictions across the world by then had taken the step. But the Supreme Court was not ready in the case of Rodriguez to make such a big decision, given the fact that they don't have the democratic legitimacy. It's not an elected body to make such a decision. So I just wanted to add that aspect of that dimension of the problematic to the discussion.
No,
Thank you.
I would like to say thank you very much, Michel, for adding that huge contextual piece. I'm sure it provides information on how these decisions are being played out here in Canada.
I think we have some questions from the public.
Yeah,
Robert, can you read that? I cannot read
yes,
it very well.
please. I don't know. Lo voy a decir en español. Tenemos 2 preguntas aquí. ¿Ha habido algún doctor que fue a prisión por ayudar a morir?
Okay, the first question is that if somebody, a physician, has been
Or-
already convicted for doing the medical assistant in dying in the past, do you know?
We don't have the equivalent in Canada of Dr. Kevorkian, who was famous in the United States because he took a very public stand. He was essentially, it was an act of civil disobedience on his part. We have a famous case in Canada in that regard, but it's Henry Morgentaler in the area of abortion. We don't have the equivalent in the area of medically assisted dying, although there were cases in front of the court. No doctors have been to jail for infringing that disposition of the criminal code.
Mm.
Tengo otra pregunta, Jorge.
Okay.
Henry and Michelle, there's another question. How many people, I'm going to say in Spanish, ¿cuántas personas han participado en el programa de Medical Assistance in Dying? I mean, how many people, I mean, those people who died in this kind of assistance?
It happens all the time, every week. It's a very common practice by now. In every city of Canada, there are medically assisted suicide performed on a weekly basis. Now, I don't have a specific number. I don't know if statistics will reveal in that context, but it's a very common practice at this time.
Many thanks, Michelle. Le pregunté a Michelle si cuántas personas, hay un registro de las personas que han escogido esta forma de camino, de esta forma de inducción a la muerte, Medical Assistance in Dying, y me dice Michelle que es cada semana hay casos, que es una práctica muy común en Canadá. ¿No es así, Jorge?
Sí, efectivamente. Well, this is I mentioned that 2 years ago, a friend from Quebec called me to say goodbye, and he says, I'm in the program of medical assistant in dying, because he has a very bad cancer in the throat, and he was suffering a lot. So it was a shock for me to hear that. He says, well, next week I'm not here anymore, so I want to say goodbye. He says, what are you talking about? So now it's if we go back to 20 years, that was not the case. But now it's so Canada is very in the front, you know, of this medical assisting in dying. Entonces, Roberto, le mencioné acerca del caso de este chico en Quebec que hizo.
I went quickly and I got from the Government Health Canada website the number of deaths of medical assisted death in Canada. In 2016, there were 1,018. In 2017, 2,800. In 2018, almost 4,500. 2019, 5,600. And 2020, 7,600. So about a 20% increase from 2019 to 2020. And that seems to be the proportionate increase from year to year is somewhere between 15 and 20%.
Wow, that's impressive. These statistics that Henry has just mentioned, and is the number of people who has choose this medical assistance in dying. Es impresionante cómo ha aumentado el número de personas que han escogido la muerte con asistencia médica, por muy fuerte que parezca. Miren, les voy a dar algunos datos que nos acaba de decir Henry. Hay aquí unas estadísticas. Simplemente en 2020 hubo 7,595 personas, pero si lo comparamos al 2019, hubo 5,600 En 2016 solamente hubo 1,000 personas, poco más de 1,000 personas. En 2017, 2,800, es decir, va en ascenso. Ya cerramos el 2020 con 7,500, mientras que en 2016 apenas iban sobrepasando los 1,000. Entonces, es una práctica muy común, como dice Henry y como dice Michelle. Jorge, no sé si quieras comentar algo.
Estoy viendo, there is another question, but yes.
Oh, all right, sorry.
Yes.
Otra pregunta. Oh,
Yeah,
sorry,
yeah.
Henry.
Yeah.
Go ahead, please.
I have put the link in the chat where you can get those numbers from the Health Canada website.
Okay, perfect. Okay.
On medical assistance in dying.
Okay.
Thanks very much. We have seen this how increased through the years, in the last years. Esmeralda, ok, gracias Esmeralda, que nos está ayudando en el contacto con YouTube. Y Jaime Rivera Sánchez nos dice una pregunta muy interesante. ¿Vacunar obligatoriamente de COVID sería una asistencia no permitida a los ciudadanos? ¿Los ciudadanos pueden acusar a quien corresponda de daño a la salud mental y física si no está en la Constitución? Y la doctora Graciela Martínez Arce, quien es nuestra directora en el CISAN. Muchas gracias por tan importante mesa. Las provincias pueden ir en contra de estos mandatos. Jorge, can you help us to translate, please?
We have a question from the director of the Center for Research in North America, or HOST. She's asking us if the province has some. What's the difference between the province and the federal federation? For example, if the Nova Scotia, can they say no, we cannot accept, or is the federal government? Can you explain that, please?
Yeah. Yes, Henri, do you want me to go ahead, or?
Well, I'll just throw in one thing, and then you can go ahead, and this will provide a little bit of context to what you're going to say, Michelle. Sure. In March of 2020, the end-of-life criterion was rejected by a court in Quebec. So that means that federal requirement in the criminal code for there being the reasonable prospect of the end of life, that one doesn't apply in Quebec. And so, but it applies in the other 9 provinces. And so, Michelle, having set up the problem for you like that, I'll allow you to explain why that works like that.
Yeah, well, first thing I think we should mention is that criminal law, unlike the United States, where criminal law falls under the jurisdiction of the states, so you have 50 different criminal codes in the United States. In Canada, criminal law is a federal jurisdiction. There's only one criminal code that applies throughout the country. On the other hand, the administration of justice, including criminal justice, falls under the jurisdiction of the provinces. Therefore, and also ELT is also a provincial matter. So obviously, when you talk about the right to die, the jurisdiction of criminal law and the ELT intertwine. Therefore, the provinces have the right to regulate, for instance, the manner that the euthanasia will take place. That's a provincial jurisdiction. But the prohibition on the right, l'aide médicale à mourir,
the medical assistance in dying.
Yes, right, sorry. Yeah, I teach that in French. It's a federal decision, and the provinces cannot refuse to go along the on the other hand. What's interesting is that because the administration of justice falls under provincial jurisdiction, in the days that abortion was illegal in Canada, prior to 2007, it was illegal because the federal government had decided it would be illegal. It was in the criminal code. The abortion was illegal in Canada. But because the provinces had the jurisdiction to manage the l'administration de la justice, to administrate justice. Once the Parti Québécois was elected in 1976, they decided we won't apply the law because the administration of justice falls under our jurisdiction. So therefore, it was illegal. Sure, it was also illegal in Quebec like everywhere else. But the government of Quebec says, sure, it's illegal, but we won't arrest people who provide, doctors who provide abortion. So now you see the complementary. Now, to go back to Henri's comment, sure, he's absolutely right. The court of Quebec, a court in Quebec has has interpreted the criminal code to invalidate one of the restrictions, like Henri has mentioned, to the right to medically assisted suicide, except that this is even though it's a Quebec judge, it is still interpreting a federal legislation.
Mm-hmm.
So this does not fall under the jurisdiction of the province. You have to understand that the Canadian federalism, I know that George is aware of that, is a very complex matter to understand what falls under the federal jurisdiction and what falls under the jurisdiction of the provinces.
Michel, very fast, and I'm going to play the devil's lawyer, something like that. What about the territories?
No, the territories don't have any distinct powers. The federal government decides the extent of the power of the territories. But because we live in a federation, Ottawa cannot say, well, we will take a power away from Quebec. That they can't do. But they can do that in relation to the territories.
The territories, okay, thank you. Okay, I don't see more questions.
Hay una
we have another question.
Otra pregunta que es sobre las vacunas. Dice, vacunar obligatoriamente de COVID sería una asistencia no permitida a los ciudadanos. Los ciudadanos pueden acusar a quien corresponda de daño a la salud mental y física si no está en la Constitución.
Okay, there is a question about the COVID, but I don't know if, well, anyways, I'm going to say it. So can you repeat a little bit, Robert? Okay,
vacunar obligatoriamente de COVID sería una asistencia no permitida de los ciudadanos.
It's regarding the right of being to have the COVID shot or not. Because I suppose that the person is asking that question because of what's going on in our national capital, probably. So what about that a little bit? Can you discuss a little bit about that?
Henri, tu veux y aller ou si tu veux?
Oh, well, okay, well.
It's a little bit out of topic, but probably could be.
What it is, if I understand the question is, should we be imposing the vaccine, the COVID vaccine, or what are reactions to the mandate to the vaccine?
Yeah, and if for example, if a physician applies, can he be judged because he did that? Or
Well, first of all, all physicians, a physician can only touch you if you consent, and secondly, a physician can only do those things to you to which you have consented. Okay. Otherwise, you get into the laws of assault and battery, either tortious or criminal. So if you refuse to be vaccinated, a physician cannot
force
you to be vaccinated.
Okay.
Now we have to go back and we have to look at what happens for smallpox, whooping cough, the childhood diseases. They are required vaccines, and I suspect that COVID may end up being one of the required vaccines downstream. The parents do not have to get their children vaccinated, but you do have to provide a vaccine certificate to register your child in the public school system. And so what's going to happen is so at the moment, schools have not been asking parents to provide, for example, smallpox or whooping cough or these types of vaccination certificates or polio or meningitis certificates because they're extremely rare. What we're seeing is we're seeing the herd mentality, the herd vaccination, the herd immunity slowly decrease, and we're seeing a little bit more instances of these diseases that we hadn't seen, especially also given the greater travel that in which people are engaging in. So people go somewhere and they're exposed, they come back, they expose other people. And so we've had these outbreaks lately that are occurring like that. And so just to come back, I think the more interesting question with regards to COVID, the COVID vaccine, is going to be whether the government is going to make that a mandatory vaccine in order to attend classes like the other vaccines are. But then also there's another possibility that could occur is that at the moment, when we look at various options that are sitting out there, the government has tremendous financial resources at its disposal. It's made smoking very, very, very difficult. Okay, we have fewer smokers in Canada than we have people who have refused a COVID vaccine. Only 50% of the population smokes in Canada presently. Okay, and every year or 2 or 3, it seems the government comes out with a more repressive measure, and what you do is you peel away about another 1% of smokers. And so we're seeing, and I suspect that COVID is going to end up being like that once we get outside of this system, is that you're going to see, government's going to be applying various types of pressures in order for people to get vaccinated, rather than saying that you have to mandatorily, you have to do it, you don't have any choice. It's simply going to make it more and more difficult for you to keep on saying no, just like it is more and more difficult for people who want to smoke now to go out and smoke. And the problem that with smoking, for example, is really the pressures that young people are under to start smoking, because we know that it's horribly addictive. And so the work has to be done at that level in order to reduce that number. And we're going to have to look at something similar, I think, to COVID. Not an answer to the question, but I think providing some context to it.
Yeah.
Michelle?
Muchas gracias. I'm sorry, Henry, many thanks for your comments. I think we have had an excellent panel from the Laurentian University, Sudbury, Ontario, Canadá. Hemos tenido una mesa excelente sobre un tema muy interesante, ¿no? Yo le pediría a nuestro buen amigo, colega doctor Jorge Virches, si nos pudiera ayudar a cerrar este panel rescatando algunos de los puntos que mencionaba Henry y destacando también lo que decía Michelle sobre el tema y que me llama la atención del tema del federalismo de Canadá, ¿no? Que a pesar de que hay una ley federal en materia criminal, en materia digamos, donde el aborto, nos mencionaba que el aborto era ilegal hasta el 2007, tengo entendido, y ya después se legalizó, es lo que yo escuché más o menos, ahorita sí, me corrigen, por favor, y pero antes de eso, aunque era legal, en Quebec, por ejemplo, mencionaba Michelle, no se podía penalizar o la provincia se negaba a penalizar a quien practicara el aborto, ¿no? Entonces es una de las peculiaridades muy interesantes del sistema federal canadiense que hemos aprendido esta mañana, esta tarde. Jorge, yo te pediría, por favor, amablemente, si nos ayudaras a sintetizar un poco y a cerrar el panel.
Claro, este ha sido un tema muy, muy interesante. Es un tema muy difícil, muy duro, porque como les decía, hablar de la muerte de una persona, ¿no? Es muy duro. Pero lo que se trata, lo que Canadá quiere hacer, bueno, es lo que se llama morir con dignidad, cómo se puede lograr evitar el sufrimiento de una persona, ¿no? Entonces, nada más quería resumir un poquito lo que dijo Henry. En las escuelas primarias se pedía un certificado cuando uno inscribía a sus hijos para que estuviera seguro que tenía la vacuna contra la viruela, el sarampión, la poliomielitis. Entonces, para poder inscribirlo en las escuelas tenían que presentar ese certificado. A lo mejor en el futuro se va a tener que hacer, estas enfermedades ya no están tan presentes, entonces ya ni se acostumbra a pedir ese certificado. Lo que sí ahora sí se está, en cuanto me imagino que en un momento dado va a ser obligatorio presentar un certificado, pero hasta el momento no lo es. Entonces, pues, hablamos fue muy, muy interesante este panel y pues creo que estamos ya un poquito fuera de tiempo. Sí, Roberto.
Perdón, aquí nos acaba de enviar Esmeralda la última pregunta. Yo sé que ya tenemos mucho tiempo en el panel, but we have received the last question. Las protestas, ¿qué pueden decir a las protestas masivas de vacunación en Canadá?
So there is another question. So what can you say about the massive protest against vaccination that is taking place? Probably regarding what the last 24 days. Do you have a comment, a quick comment, because we are already out of time?
Michel? J'ai pris la dernière, tu peux dire.
As you know, Canada is very closely integrated to the United States. If the Trump supporters and the ideology that came out of that movement has made babies in Canada. If you look at the people, if you watch TV and you look at the people on Parliament Hill who are demonstrating, you'll see that they're all white, or it's white nationalism. It's a right-wing movement, and the American are subsidizing those demonstrations to a great extent. So you have that "Make America Great Again" philosophy that is going through the borders. That's part of there would be a lot to say about that, but it's one component of the situation.
Thank you, Michel. Robert, shall we conclude? I cannot hear you.
Sorry. Muchas gracias. No sé, Henry, ¿quiere cerrar con algo? O si no, ya cerramos esta mesa, este panel. Jorge, entonces les agradecemos mucho. We really appreciate your time in Canada, in Sudbury, in Ontario. Many thanks for your participation. We really appreciate in CISAN UNAM. Hopefully we can have another panel in the near future and another kind of collaboration, probably an academic publication. Many thanks again for your time and your participation. And many thanks, Jorge Birches. ¿Puedes decir las últimas palabras, Jorge, para cerrar el panel?
Pues Michel, thank you very much. Henry, we are really delighted to have you. It's always very, very interesting to have you. We learn a lot, and I hope that we can continue in a collaboration in the near future. I know that you are extremely busy, and we appreciate your time, and that you took the time, and we passed our time already, but it was so interesting, and the question that people wanted to know all about the topic. So with this, we want to close, and thank you very much, and enjoy the day.
Gracias por la invitación. I don't know if I'm saying that right. Thank you very much.
Okay.
Gracias. Hasta
Bye.
luego.
Bye-bye. Thank you very much.
Okay.
Adios.
Bye-bye. Thank you very much, Roberto, for doing this.
Okay, thanks, Harry.
Okay.
See you soon.
And thank you for
Hopefully we
pushing.
can do it again. Bye-bye. Thank you.